Welcome to DOT Driver Qualifications and Background Checks. I'm Mike Coffey, President of Imperative Information Group, and I'm going to talk today about a lot of issues, and you see them on there on the left-hand side of the screen, concerning the Department of Transportation's Federal Motor Carrier safety regulations. Why am I doing that? Well, I'm an HR guy who's been in and around HR for more than 20 years. For the last 17 years, though, I've had the pleasure of being a consultant to our clients around all kinds of employee selection and employee relations issues, which is where my passion's always been. And on the employee selection side, we're also a background investigations provider, and that's what really generates the revenue and keeps my kids in orthodontics. But I speak at HR Southwest, and I've spoken to just about every HR chapter in Texas and Oklahoma and around the country. I've spoken to a number of conferences and all of that too. But why DOT background checks? Well, quite honestly, when we first got into the background screening business 17 years ago, we didn't do DOT background checks. I've got this thing where we won't do it unless we really feel like we're experts in it and we offer the best solution. But back in 2008, when the economy started to tank, in a number of our clients, we saw the HR department get combined with the risk management department, who had traditionally handled the DOT background check process. And so suddenly some HR folks who were clients were calling us and saying, hey, we need help on this. We don't, can you do this for us? We're not sure what our requirements are. And they just laid off the risk manager. So we dug into it and found that, first of all, reading the regs and talking to some experts, especially a couple Texas-based consultants who specialize in DOT, we found that a lot of our clients didn't understand the requirements and maybe weren't following them as closely as they should. And it turns out, as I understand it, most employers that they're out of compliance with their DOT requirements don't realize it until after something's gone wrong. They've had an accident or something like that, and you've got either the state or the federal DOT breathing down their necks. And so we figured out how to improve what our clients were doing. And so this webinar talks about the ways we help our clients and the information we've developed and expertise we've developed in making sure that we can deliver to them. All that said, I'm not a lawyer and I'm not a DOT regulator. So if there's something that I say today that sounds different than what you're doing, go get into the regs and look at that, and we'll send you links to a lot of that when you get the notes after the webinar. But also talk to your own safety and risk management experts. And if you see something that I say that's wrong, contact me and let's talk about it. It's possible I wasn't clear. It's possible, always possible, that there's something I'm misunderstanding. But I've given this webinar as a webinar, this presentation as a webinar, half a dozen times over the last few years, and given it live at different HR training events, and no one's ever actually come up and said I was wrong with anything. So if we can help clarify anything, though, don't hesitate. And also, throughout the webinar, feel free to put your questions down in the question box, and I will get to them all at the end of the session. And I'll stick around as long as we need to make sure all questions are answered. Sometimes there are a few, and sometimes there are a lot. So you tell me what you want to know, and I'll stick around and answer as best I can. Also, after the webinar, we will be sending out everyone a link to download the slides and notes. And so it just won't be the pictures, it'll also be the notes on each slide. And to get the HRCI and SHRM credit if you're looking for that. So watch for that email, and what we'll ask is that to get all that information, you just take a quick survey, tell me how I did today, what we can do differently, and we'll go from there. Okay, so let's get rolling. Let's start with a quick poll. Do you currently have DOT covered drivers? So just let me know. I'm assuming most of you do. There may be one or two of you who just need some feedback we need, either want to know about it, or maybe you just needed HRCI or credit for your research, and that's fine too. Okay, I'm going to go ahead, and about half of you voted. Let me get it to 75%. A couple more if you jump in there. I mean, we got a small group today. There's, I think, about 35 people registered, and really right now we've only got 24 people on the line. Okay, so I'm going to close that poll. And according to your responses, 67% of you do have, let me share the result there, 67% of you do have DOT covered drivers, and about a third of you don't. So the third of you who don't, I hope you find this interesting anyway. So let's, and doing some of this just to kind of get an idea who's in the audience. So let me ask the next question. Who currently handles your DOT mandated background checks? This is always interesting because every time we do this, it seems that more and more the HR folks are having to deal with it. So, okay, so about half of you voted. Okay, go ahead and close that. Okay, share those results, and you can see that about half of your HR folks are handling the DOT background checks, and safety of risk management's doing it, or some else in your internal staff's doing it, and then about a third of you are sending it out to your background screening partner. And I know a number of you are our clients, and so I'm going to do the shout out and say hello to all of you, but and we certainly are glad to help you in that front as well. Okay, that's helpful. And let's see, next, I think there's just two more, I promise. How well do you think you understand the DOT requirements? I want to make sure you learned something today, but just kind of give me an idea of where you think you're at. Okay, well, good. None of you are alone. Okay, we're going to close that poll and share those results. And as you can see, none of you think you should be teaching this webinar. I hope at the end of the webinar you think that I should be teaching it. About a quarter of you say you've been doing this a while, you've got it pretty much under control. And what I find there really is I see a lot of employers who are doing it right. They just don't know why they're doing it right. It was handed to them, and either by their predecessor or by a safety consultant, and they're doing what they're supposed to. They just didn't know why they were doing it. And so hopefully this webinar will help some of that. And so the rest of you are kind of uncertain. You're not really sure that everything's right, and hopefully we can help you figure out some of that as well today. And last question. And from your experience, if you're involved in it, how well does your current process work? Oh, I closed that too quickly. Yeah. Hope I can reopen that. Let's see if I can. Well, I see I've got twitchy fingers and I'm on my MacBook, so I don't think I can reshare it. Well, I won't find out how well your process works, but we'll go from there. I've got quick fingers and I'm on my MacBook for a change today. Okay. So what we're not going to discuss today, I'm not going to do a webinar on the DOT Part 40 drug screening process, on substance abuse providers or the rehab programs. I'll touch on a couple of those because they're involved in some of the inquiries that employers make, but that would be a whole webinar into itself. And we help clients on the drug screening side with that stuff, but like I say, getting that right and understanding your requirements for random sampling and all of that is a whole nother world, whole nother webinar for sure. We're not going to get into driver physicals or road tests or really the driver qualification file maintenance stuff. There'll be a few things that may reference to the file, things that you need to have in the file from this process, but we're not going to get into DQ files very deep today. But what we are going to talk about are the FMCSRs that do affect driver background checks, including the employment application requirements, which is completely different than what you're used to for your non-DOT applicants. What the inquiries to previous employers that you're required to make as a DOT employer, and the former employer's responsibilities in responding to those, and the driver's disclosures and rights. So let's just jump into that. The Federal Motor Carrier Safety Administration is the division of the Department of Transportation that handles commercial motor vehicle operations on the interstate highways and in some cases the intrastate highways. The FMCSRs are the regulations, and they are, if you're a DOT covered employer, they're basically the law as far as you're concerned. Unlike some other government agencies like the EEOC, who just publish their opinions, the DOT publishes their regs out for public comment. They get feedback, and then they make determinations and rulings and publish actual rules that you have to follow. And that's what we're going to talk about today. So those FMCSRs are, they're all available on the internet, not in a very accessible, easy to use way, but they're all out there. And different sections of the FMCSRs apply to different kinds of drivers of certain kinds of vehicles. And not just drivers, we'll say drivers a lot, but when we're talking about some of the safety sensitive position stuff, especially where it's related to drug and alcohol, if the vehicle that this person is touching, whether they're a mechanic or a driver, is covered by those regs, then those people, even if they're not drivers, would be covered by the regs. We'll talk about that a little bit more. But really, the FMCSRs are a maze. There are times where they overlap with each other. They seem to conflict in some places. If they don't conflict, at least they have different requirements for the exact same research. And so you just end up, depending on which regs apply, you just take the more, basically the more onerous or the more detailed requirements and apply those. So the parts we're really going to talk about today are Part 382, which covers alcohol and controlled substances with regard to commercial motor vehicle operators. And that Part 382 deals with commercial motor vehicle operators and incorporates Part 40, which is the drug and alcohol testing regulations in FMCSRs that apply across different areas, not just commercial motor vehicles. Then Part 383 covers commercial motor vehicle driver's licenses and what's required to get a CMV. And then Part 390 and 391 covers the minimum qualifications to be a driver and what the record-keeping requirements are there. And we're going to get into those. But it can be kind of confusing. I've got a little table later that helps you understand what applies to what circumstance. But let's look at a few definitions first. What is a commercial motor vehicle? And this is critical. Understanding what a CMV is will help you determine what regs apply to you. So let's look, because you've got different definitions according to which section of the regs you're looking at. So you'll see on the table there on the left, you've got 382 and 383, and you've got Part 390 and 391 on the right. So the regs, and I'm not going to read all of this, but the regs go and they look at the weight of the vehicle. And so as you can see, the heavier vehicles are covered by 382, where lighter weight vehicles are 390 and 391. Plus, of course, 382 would apply to everything that 390 and 391 would apply to everything that 382 is, because they're more like a minimum requirement. So we look at the number of passengers, what kind of hazardous material placarding are required, and ultimately, this is how we figure out what applies to circumstance. So you would look down this list, and basically you can look at the number of passengers and the weight of the vehicle and determine pretty much which of these regs apply. So if you qualify in the left column there, Part 382 is going to apply, as is Part 383. And then if you're in a smaller vehicle, those may not apply, but Part 390 is going to apply to you if you meet those minimum weight or passenger requirements on a commercial motor vehicle. That's probably clear as mud. You'll probably want to get the slides, look at the notes and things. But basically, if you're covered, if you're a DOT covered employer, 390, 391 are going to apply. 382 and 383 are going to apply for the heavier, larger vehicles. Now, 390 and 391 technically, from the federal point of view, only apply to interstate commercial drivers. So people who are, driving from one state to the next and crossing state lines. However, and so it's easy to say because from the federal point of view, that's right. But all the states have at some level incorporated Part 390 and 391 into their own states' DOT regulations. So even if you're driving a vehicle that's small enough that Part 382 doesn't apply to it, and you're only driving intrastate inside your own state, you might think, well, none of this really applies to me then. Well, the fact is, your own state has definitely incorporated some, or in most cases all, of Part 390 and 391 to commercial motor vehicles as well. So even I'm going to talk about what applies and doesn't apply from a federal point of view. Here in Texas where I'm at, or in the other states, those regs have been adopted for intrastate drivers too. Some states have changed a few things about driver age and things like that. But generally, and especially in the area where we're talking about, the states are going to require the same thing. And so if you have questions about that, you can go ahead and post them, but I hope that's kind of clear as mud. The other definition we need to get into, it comes out of the 382 section, and it talks about what is a safety-sensitive function. Now remember, 382 applies to the larger vehicles, and if you're qualified as a commercial motor vehicle under 382, this is going to apply to you intrastate or interstate. And so what is a safety-sensitive function? It means all the time that a driver hangs around the vehicle, waits at the employer or at the shipper or at a terminal, waiting for a call to ship out or waiting to be dispatched or for a truck to be loaded, those kinds of things. That's to say, they're covered as performing a safety-sensitive function, even if they're just in the break room watching TV, waiting for the truck to get loaded. Anytime they're spending inspecting equipment, things like that, or working on equipment, that's safety sensitive, which makes sense. I wouldn't want somebody who was impaired working on the truck that's about to hit the road. Of course, all the time that they spend operating the commercial motor vehicle would be safety sensitive. And any time that they're in the vehicle, so if they're riding shotgun in the vehicle, that would be a safety-sensitive function too. So if you've got guys riding at tandem and swapping out, then that's a safety-sensitive function as well. And then loading or unloading a vehicle would be a safety-sensitive function. So basically, if they're in or about the vehicle, you can pretty much bet that it's a safety-sensitive function, including when they're broken down on the side of the road. So those are the definitions, and just so you understand that safety-sensitive function, that really does kind of expand beyond just that term driver, because there's a lot of things not involved in actually driving a motor vehicle, commercial motor vehicle involved there. And again, that's under Part 382, so that's really, those definitions apply to the larger vehicles for both interstate and intrastate driving. So let's get down to the nitty-gritty. How is your employment application for DOT drivers different from that of your regular employees? Well, we'll get into some of those. The employment application has to be furnished by the motor carrier, so you can't take a resume and hire somebody based off a resume. They have to complete your application. The applicant actually has to complete it and has to sign it. So they can't have someone else come in and fill it out like you probably in your regular employment scenario have from time to time for certain positions. people who maybe whose English isn't proficient or whatever, and they fill out the employment application, or they bring somebody with them to help fill out the employment application. Well, under the regs, and these regs apply to everybody, the applicant has to complete the application themselves, and they have to sign it. Okay, and so what has to be in the application? Well, certainly the name and address of the motor carrier, the employer. Then the applicant has to give their name, address, date of birth, and social security number. Now, you probably don't, on your regular employment application, have date of birth as part of the employment application. If it's a DOT driver, the application has to have their date of birth. And the reason you don't have it is because you don't want an allegation that you used it to make an age discriminatory employment decision. But under the DOT regs, you have to have that on the driver's employment application. And then you need their addresses, all the addresses at which they've resided the last 3 years. And so that's something else you probably don't have on your regular employment application, actual addresses, every place they've lived in the last 3 years. And believe me, I've seen some of these drivers' applications, and they have a lot. This is a really transient population. They move around a lot, depending on, especially if they're attached to the oil field, things like that. They move. They may have 3, 4, 5 addresses in the last 3 years. And then, of course, the date on which the application is submitted. And you'll see a lot of what you're going to see on the screen today, like I said earlier, is quoted right out of the regs. This is my most text-intensive presentation. I wish there were ways to make some of these interesting photos, but we just haven't figured that out. If you've got ideas, send them to me. The application also has to have a place for them to list each of the driver's licenses that they have, unexpired commercial driver's motor vehicle licenses. So if they've got a CDL in another state, they should have to list that on the application. They shouldn't have more than one. They should, when they move to Texas, they should give up their New Mexico one. But on occasion, you'll see somebody who somehow has managed to get 2 of them. They're supposed to list all of those. And then they've got to give you some information about their experience operating a commercial motor vehicle, what kinds of equipment they've operated, that kind of thing. And then a list of all the motor vehicle accidents they've been involved in the preceding year, in 3 years, and a list of all the violations, tickets that they've gotten in the prior 3 years as well. And then they've got to have on the application a statement setting forth in detail any issues that they've had where their license has been suspended, revoked, or denied. There's got to be a place for them to answer a question, basically, usually yes or no to that, and then a place, if it's yes, for them to give some information about that. So these are things that wouldn't be on your normal employment application. Then all their employers in the last 3 years, and this is all employers, DOT and non-DOT employers. They've got to list every employer they've had in the last 3 years, and the date they were at that employer, and their reason for leaving that employer's employ. And then they also have to indicate for those employers in the last 3 years whether they were subject to the FMCSRs in that position, in whatever position they had. So were they a commercial motor vehicle operator for those jobs? And was that position a safety-sensitive function subject to alcohol and controlled substances? So were they operating vehicles of a sufficient size that they were subject to the DOT drug testing? And a list of all of their, so if we just said for 3 years, we got to list all their DOT employers. Now, outside of that 3 year, I'm sorry, I messed it up. All employers for the last 3 years have to be listed in the application. Now, 3 years to 10 years, for that 7-year period, we need to see all DOT covered employers if they were covered, for those purposes. So if they may have worked at McDonald's as a fry cook for 2 years. If that was within the last 3 years, you'll list it. If it was 5 years ago, they won't list it. They'll only list their commercial motor vehicle jobs from that 3 years plus to 10 years range. And that's under 391, and that again applies to all the vehicles we're talking about here. Now there's a special set of requirements, which is interesting, for Part 383 for those larger vehicles. And that requirement is just that they list all of their commercial motor vehicle operations in the last 10 years. So they just need all the names and addresses of those employers in the last 10 years that they operated a commercial motor vehicle, and the dates of employment and the reasons for leaving employment. So this overlaps with 391, because 391 has already got all the commercial motor vehicle people listed. They're already under the 391 requirements. So this is kind of extra. So here's kind of what it looks like. You've got your all employers, regardless of whether they were operated a commercial motor vehicle within the last 3 years. And then from that 3 to 10 years, you're going to want all their commercial motor vehicle employers at a minimum. That doesn't preclude you from asking about other employers, and I certainly, putting on my HR consulting hat, recommend that you do ask them about all employers in at least the last 10 years. But for these regulations requirements, the application only has to cover CMV employers over 3 years, or non-CMV employers within the last 3 years. Let me say it that way. So one more summary to try and make it clear as mud. All employers in the last 3 years, and then in 7 additional years to get out to 10, the CMV employers only. Hope that helps. And here's what our employment application looks like. And again, you'll get the slides and notes later on. And if you want a copy of our DOT employment application, you can send me an email. I'd be glad to share what we've put together as a sample for employers, for our clients to start considering. Just send me an email, and I'd be glad to give that to you. And so this is how we do it. We ask them, are they employed now? May they contact, the employer, and then that information. Then here's the questions we ask about: did they operate a commercial motor vehicle, and all that. And now you can see, because this is the sample we put together, we say give a complete record of all employment during the last 10 years, because my advice to employers is to get all of that employment history for the last 10 years. So it's verifiable. You can see any big gaps in employment that may come up, because sometimes that's a red flag, and we want to make sure that we understand what those gaps were, and that there's some reason to understand, for that to be reasonable, and that, they weren't in jail someplace for 6 months or a year or more, and just don't want to tell you about it. So the other things that the employment application have to have under 391 are a certification where the applicant certifies that they really completed it and that the information is true and correct. That's going to be on the application, which is, again, language maybe different than what you have in your employment application. And then, in fact, let me go back to this. You probably, on your normal employment application for all positions, don't want that requirement that the application was completed by me. You may be challenged that under the ADA and possibly some other laws that offering an English-only employment application could be deemed discriminatory. So you don't want this to have to be completed by the applicant exclusively for a non-DOT employee. That's my HR consulting advice, but I think that's probably pretty sound. And now there's also, the applicant has certain rights, and you've got to notify that applicant on the application that all the information that they provide you is going to be used to investigate their safety performance history. It's going to be, that kind of language has to be on the application. And you've also got to give them a notice of their due process rights. And we'll get into those. So if they want to dispute the accuracy of the information received from previous employers, they have a right to do that, and there's particular ways to do that, including they have a right to review the information provided by previous employers. I mean, we've all been doing this long enough. We know there's no such thing as in secret or, you know, confidentially, I'll tell you about this applicant, but just don't tell him I said that. That's not reasonable. In the DOT area, they have a right to get that information. And even in the regular employment area, even if they don't have a right to, to know what your discussions with a previous employer are, it's not, they don't have any kind of real, the former employer or you don't have any real ability to stop the applicant from learning about what was said if it comes down to litigation. Either documents will be subpoenaed or you'll be deposed and you'll have to tell the truth about what was said. So whenever we're talking to employers or former employers on behalf of our clients, we always stress that even if they say, well, I'll tell you this off the record. Well, there's no such thing as off the record. If you tell me, I'm going to have to, we're going to share it with the employer, and that may factor into their hiring decision. So that's important to understand. But they've got a right to review whatever information came from the previous employers. If they think the information is incorrect, they have a right to have that corrected by the previous employer. They can dispute it back to the previous employer and then get that information updated and re-provided to the prospective employer. And then if they think the information is incorrect from the previous employer, but the previous employer says, no, it's correct, I'm not going to change it, then they can put a statement in the previous employer's file that they have to share with all the employers that they're going to share that negative information with. So if, and it's got to be shared forward. So you as the employer have a responsibility to collect that and to share it going forward. We'll talk more about that in a little bit, but you have to notify the applicant on the application of all these requirements. Then you've got also under Part 40, for those applicants who are covered by Part 383, there's specific requirements about what you have to ask the applicant about their drug and alcohol history. And so first you have to ask them if on any pre-employment drug and alcohol test, they failed it or they refused to test. So if they test positive or refuse to test on any pre-employment drug test, you have to tell them that. And then and if they didn't get the job, obviously they need to know about that. So and that's only in the last 2 years. So have you, basically you're asking them, have you failed or refused to take a drug test in the previous 2 years? And it's kind of on the honor system on the refuse to test, because how would you ever know if they didn't ever go to work for that employer? But again, you have to ask. But what they don't require, which is interesting, is that you ask if as an employee they ever failed or refused to take a test. So you have to ask them if they failed a pre-employment test or refused to take a test pre-employment, but you don't have to ask them, although I recommend you do, if they've ever failed or refused to take a test in the employment context. So it's only pre-employment that you're required to. But again, our sample application to employers goes ahead and includes the other part of that question too, because I think it's important for you as the employer to know, okay, yeah, well, I did fail this test, a year and a half ago or 2 years ago, working for another employer, and I need to follow. Then you can be sure you follow up with that employer when you do your inquiries, which we'll get to in a bit, and make sure they tell you and give you the appropriate responses about all of that. So now what's required on your background check specific to that's the end of the application piece. So let's talk about what's required now for the background check piece. You've got the employment application, the driver appears qualified, so you're going to start checking references and doing all that stuff. Well, you want to order a criminal background check, definitely. It's not required into the regs. But you do have to inquire into their safety performance history for all drivers and their alcohol and drug testing history for those larger vehicles, those safety sensitive positions, those vehicles that we talked about earlier that are the larger, higher occupancy or heavier weight vehicles. So let's get into those. Let's talk first about safety performance history and what you have to ask these folks' previous employers. You've got to make the following inquiries, and this is all stuff right out of the regs. First of all, you've got to each state where they've held or currently hold an operator's license, a CDL, in the last 3 years, you've got to get a copy of their driving record. The way you do that is typically through your background screening company now. First thing you want to do is run what's called the CDLIS, Commercial Driver's License Information System. And that's basically a nationwide database of everybody who's had a commercial driver's license. And then, so you run it, you say, well, look, you've had a CDL in Texas and in Washington State. Well, you want to go ahead and run the driving record in Texas and Washington State for that driver. Then you also you want to do an investigation, or basically is inquiring into their safety performance history with the DOT regulated employers that they've worked for the last 3 years. So you're looking at their employment application, and you'll remember they had to list all employers in the last 3 years. Well, you're under the regs, even though they have to list all employers, you only have to follow up with those who were for which they operated a commercial motor vehicle, which you remember is one of the questions you ask them on the employment application. The other issue is I would still recommend, even if there's only one CMV employer in the last 3 years, that you go ahead, if they've got other employers in the last 3 years for which they weren't operating motor vehicle, that you still do your standard employment verifications for them. You still want to do it even though it's not required by the regs. The regs is primarily about their safety history operating a commercial motor vehicle. And so you can do this investigation in a lot of different ways. You can pick up the phone, you can mail them a letter request, or send them a fax, whatever. Some responding employers, some previous employers, especially larger employers, have it automated. So, and some of them even charge, which I don't think they can legally do, but they do. And do you want to you want to take the time to argue with them about it? So, but there are multiple ways you can get it, and basically they're telling you you can do it any way it takes to get the information. And then you've got to keep a written record of your attempts to try and get that information, and who you contacted and when and all of that. And we have had clients who've had DOT audits, and they've been in good shape because when the auditor asked to look at those files, they've had in our inquiries, in our report, we actually say we contacted this person on this date and received this information, or they were unresponsive and we contacted them on this date and this date and this date and this date. And so they've got history of who we tried to contact and how, so that in the file they're covered, especially when an employer wasn't responsive. If you can't contact them, you've got to have a reason why. So we tried to contact them on these dates, and they were unresponsive, or they were out of service, or we couldn't find we couldn't find a valid phone number. And your drivers some of them are real knuckleheads. I mean, they'll write down that they work for Charlie's Trucking, and in some town, and you look everywhere and there's no Charlie's Trucking, and it's really frustrating because that's probably not the name of the company they work for. They work for a guy named Charlie, and he was the manager, and it was really XYZ Trucking Company or something. So, but some of them, as amazing as it is, don't know who they worked for. Don't know the legal name of their employer. And now, if a previous employer doesn't respond to the inquiries, then you, as the prospective employer, have an obligation to report them to DOT and keep a copy of that report in your DQ file. So in the driver investigation part of the DQ file, which is something you're going to keep separate from the regular DQ file. But you've got a responsibility to report them. It doesn't happen a lot, and I can tell you why I know it doesn't happen a lot, because we do that on behalf of our clients, and we regularly get calls from DOT saying, hey, we're trying to follow up on this report. We don't get many of these, and so DOT seems to think all these employers are really responsive, but we know from experience that they're not. So I think a lot of prospective employers just aren't reporting the other employers to DOT. And of course, if they don't have any DOT history, there's nothing to report. You just put a note in their file that there wasn't anything to investigate if you're their first commercial motor vehicle job and employer in the last 3 years. So here's what do you have to ask? Okay, so we've said these are all the things you've got. These are who you've got to ask things of and how. But what do you actually have to ask? So if they operated a motor vehicle within the last 3 years for an employee, you have to ask this information. First of all, verify the general driver identification and employment verification information. What is general employment verification information? This is not defined any further anywhere that we've ever found, and every employer looks at it differently. We always try to get all the things you would normally try to get from a previous employer. Wage verification, dates of employment, certainly title, and we always ask for termination reasons. Sometimes we get it, sometimes we don't. And we always ask for eligibility for rehire. And then we always ask, and again, this is outside the regs, but this is just a good practice to hopefully get some actionable information, but also to mitigate your risk later and your potential liability. We always ask, if the person ever acted in a threatening or coercive manner, if they ever acted in an unsafe manner, and we've got several other questions. Was there ever any reason to question their integrity or their honesty? Those kinds of questions. We've got a series of them. And we get answers on those about 30% of the time, 25 or 30% of the time. But we always ask, and this is just background checks 101 stuff, because in the future, if this employee, while he's your employee, does something, injures somebody or does something that maybe would have been forecast or predictable based on their past employment history, you've got proof that you at least asked that previous employer about their history and their any risk that they may pose. And so if the previous employer refused to respond to that question, at the very least you've got you hopefully will have proof that, hey, we tried to find out, they wouldn't tell us, and that may help mitigate your liability. And then they also have to give you information about any accidents that that driver had, and anything else they want to provide that they're maintaining in their files about the person's history. So if they've got an accident register, then they need to provide whatever's listed there. But then beyond that, they also need to provide you, hopefully they can provide you anything else that they've got. So just because it didn't hit their accident register, there may be other things that they need, that they're holding on to, and hopefully they'll share those with you as well. So now that's their safety performance history. Now what do you have to ask about their alcohol and controlled substance inquiries for those applicants who are covered by who are operating the larger motor vehicles, parts 382, 383. What do you have to ask those employers? Under 391, which applies again to all employers, you've got to ask. So let me clarify this. 391.23 applies to all employers. So you've got to ask these questions, but they're primarily only going to be responsive from those positions where the person was operating a larger vehicle that was a safety sensitive function. So, but you got to ask it of all their previous DOT regulated employers, regardless of how large the vehicle was. And you'll ask in your employment application, was this a safety sensitive function? And most of your employees have no clue of whether it was or not. And so even if they're operating smaller vehicles, they don't know if it's 382 and 383 apply, or if it was a smaller vehicle that they didn't have to have the mandatory drug testing and all that under the regs. So they're going to say everything was safety sensitive, and so you're going to end up sending that to a lot of employers whose responses are going to be, he didn't operate in a safety sensitive position. So whether you're going to ask them whether in the previous 3 years they ever violated the alcohol and drug requirements under Part 382. So did they ever have a dirty test, or refuse to test, or failed to complete a substance abuse program if they had a positive test? So yeah, did they ever fail? And you have to specifically ask them, did they ever fail to enter into a rehab program and complete it? And then if they did successfully complete a rehab program, you also have to ask them if after completing that rehab program, they ever again had a second failure, alcohol test or drug alcohol over .04, verified drug test, or a refusal. So that's a unique question, and it really is kind of hard to make the responding employers understand what you're asking. So you know, because they've already told you in the first question that they never failed the test, and then the second question is, well, if they failed the test, did they complete the SAP program and then fail it again? And it seems like the first question should have answered the second, but because you're using a standard form, you're asking it twice. And then the applicant has to give specific written authorization to you as the prospective employer that you share with the previous employer that's really specific and allows you to share, it allows them to share that drug and alcohol testing information. Your standard release on your employment application isn't good enough for that previous employer to share the drug and alcohol testing information. And we'll get into just a second exactly what's required there. So that's under 391. You've got to ask about those. Now, if it's covered by Part 40, the position you're considering this person for is covered by Part 40. It's a larger position, a larger vehicle, and all of that. Then you've got to get that specific written consent for the release of that information and give it to those prospective previous employers as well. And then what is specific written consent? And here's where some employers get in trouble. They have some sort of blanket authorization that says the applicant agrees to share this information, that all entities can share this information with XYZ Trucking. Okay, but it can't. It's got to be particular to or not. Actually, let me get that wrong. I release all employers to share my drug and alcohol history with anybody who inquires. You can't do that. The specific written consent has to say that I, as the applicant, authorize my previous employers to release the information to a specific employer, so XYZ Trucking. So if your background screening company is making these inquiries on your behalf, then that release needs to say, like in our case, it would say, I authorize all previous employers in the last 3 years to share my drug and alcohol testing history with Imperative Information Group on behalf of XYZ Trucking or whoever the prospective employer is. That's really important because if your background screening company is doing this for you or somebody else is doing this for you, then because that previous employer can't share it legally with a third party unless they're named specifically on that authorization. So you might want to go back and look, because if you're doing any of these verifications or inquiries through your background screening partner, you need to make sure that they're named in that authorization document. And now under 40.25, again, on these larger vehicles, you only have to ask about the history from the employers in the previous 2 years. Of course, under 391, we already said you've got to look at the 3-year history. But in this case, this particular set of regs only going to apply to 2 years. And you're going to ask them specifically about alcohol tests with a result of .04 or higher, any verified drug tests, or any refusals to be tested. So again, we're talking about the last 2 years. Or any other violations of the DOT drug requirements, including completing an SAP rehab program. And if they did violate a DOT or drug or alcohol regulation, did they complete the DOT return to duty requirements, including having clean follow-up tests and all of that, completing the SAP rehab program and having clean follow-up tests. They were able to do that. And then also in this case, if this previous employer did receive drug or alcohol information from yet earlier employers, they have to give you that too. And every now and then we'll get a call from an employer say, I can't give you that information. You're asking for it, but we can't share what an employee, a previous employer to us said, and I have to point them to this section that we actually have to ask for it and that they're supposed to provide it. This is real detailed stuff, and I promise we're getting really close to finishing up here. But I just, when you see the actual documents, especially if you ask the CR, DOT, application, and authorization documents, then when you see them, you say, why is that there? You can come back here, and it'll tell you exactly why each of those requirements are there. You've got to ask for this information ideally before they ever perform any safety-sensitive functions, but nobody does that. If they look qualified and they've tested your requirements, okay, most employers are putting them to work because they know those previous employers are going to take their time in responding. And even though they're not really supposed to take their time, they're supposed to respond quickly, and we'll talk about that in a minute. They often take up to 30 days because they know that they're not going to get reported to the DOT for 30 days, and we'll talk about that. But if you haven't made a good faith effort within 30 days, you can't let them operate a motor vehicle after that. So if you've, in a good faith effort, when I've talked to DOT investigators, they're expecting to see 2 or 3 real attempts to get the information. So if you send it on day 1 and don't follow up and don't do anything, don't hear anything back on day 30, that's not a good faith attempt according to the investigators that we've talked to. So you want to see them you want to make 2 or 3 attempts and have good documentation of who you contacted before you let them work after 30 days. And if you find out that they have failed a drug or alcohol test or had some sort of violation, refused to test or whatever, then you also have to get proof that they complied with their return to duty requirements and they have completed under the regs an SAP rehab program. Okay, so and that subpart O is the substance abuse professionals section of the regs. So you want to, so if you find out that they failed, either they tell you they failed or on the application, or a previous employer tells you they failed, then you've got to get documentation that they actually did comply with those return to duties. And sometimes the previous employer has that, but if they don't have it, the employee has to give it to you before you can let them go to work. And then you've got to have a record of all the information that you obtain and your good faith efforts to obtain that. And you got to keep that for 3 years from the date that person first starts to perform safety-sensitive duties for you. Okay, so if you're the previous employer, what are your requirements? What real requirements are on those previous employers when you're calling them or if you happen to be them? Well, you see, under Part 40, the drug and alcohol section, once they receive that former employee's specific written consent, where it said that I authorize XYZ Trucking to release this information to Imperative Information Group on behalf of whomever, then you're supposed to immediately, and that's in the regs, immediately release the requested information. But we all know that often it's 30 days. On day 29, receive it if you continue to pester them. And what we do is on about day 27, send them a note saying, hey, we're reporting you to DOT on Friday if you don't give us a response. And usually that gets us a response, because they don't want DOT coming around. And see here, okay, so and then you have to respond to under 391. That's the safety performance history stuff. They do have to respond within 30 days, and so that's where the 30-day stuff comes from. But they're supposed to give the drug and alcohol stuff immediately, but they they tie everything back to the safety performance stuff and only wait up 30 days. Then you've also got to make sure the information is accurate. You've got to provide the contact information. If the driver says, hey, that's not right, then they want to know who to call and yell at. You've got to leave that information. So it's not just safety department. It's specific contact information. So who do they contact? If I call the safety department at a really big company, I'm going to get the runaround. I need to know who to talk to. Jane Smith, at extension 105, that kind of information is what we're typically looking for when we're trying to get accurate information for our clients. And then you got to keep every request that you get and your response, you've got to keep for 1 year. And you also have to have some process for sharing this information that keeps it secure and that it doesn't get disclosed to people who aren't involved in forwarding those records. So, you don't want to, leave them laying around on your fax machine after you've sent them, or have, just have them where regular employees can access them and things like that. You want to keep it confidential. Now, the driver does have a right to dispute some of this information. If they believe the information is incorrect, then first of all, they have a right to review the information that the prospective employer received by giving the prospective employer a written request for that information. And then the prospective employer has to respond within 5 days. Then, if the driver believes that information is incorrect, they have the right under the regulations to request that the previous employer correct the information, and they send that to that request to that previous employer directly. And then that previous employer has 15 days to review it. So you get a little over 2 weeks. You got to look at the information and then decide if the driver is right, that the information was incorrect, and then correct it, or notify the driver that you're not going to change anything. I don't agree with that information is incorrect. It actually is correct. And you have to notify the driver if you're not going to change it. And then if you tell that driver, I'm not going to change this information, he has a right to put a rebuttal statement in your driver safety performance history file that you have to share with everybody that you've you provided information to, and all future people to whom you provide the information. So if you think the information is accurate, the driver doesn't, but he gives you a statement saying why he thinks it's incorrect. And often these statements, when I've seen them, I don't see a lot of them, but when I see them, it's more about, this isn't fair, or some lame excuse about why their drug tests were failed. So but when you see them, that's what it is. If you ever get one, and your responsibility as a previous employer is to make sure you share that with everybody going forward. Okay, last question of the day. I'll try not to get fancy fingers here too quick. Did you learn anything? Let me know. Good. Well, that's looking good. Good. So hopefully somebody learned something. Okay. I want to close that. So 80% of you said, yeah, you learned something. So that's good. I'm glad for that. 13% said, yeah, it was a good refresher. And 7% of you, we're a small population. There's only 26 on the line. So 7%, which maybe only 1 or 2 of you, said you didn't learn anything. Well, I hope at least you needed the HRCI credit so that it was worthwhile for you to spend an hour with me, and you did stick it out, so I really do appreciate that. Those who didn't learn anything, if there is anything that we could do to make our, oops, there's you go. Well, I guess I didn't share that with you. Let me share that with you real quick. There you go. Poll results were yes, 80%, 13% nothing new, and 7% no. So I don't get many no's. So if there's something that you would have liked to see differently, or there's something you were expecting to hear that you didn't, please take the survey at the end. When you get the email, I've got really fat fingers here. They keep popping up. There we go. and let me know what else would have been helpful. I don't nobody's asked any questions yet, I don't think. Let me look here. Somebody did say, I'm glad I don't have to deal with this at my current employer. Great information. Well, and that's a client of mine, so hi, Casey. We're glad to be of help. But if anybody has any questions, I'm certainly going to stick around if you have any. So once again, what's going to happen is you will get an email later on today that'll have a link to download the slides. And the slides have some notes on them, but these slides, most of the notes are on the slide. And also, if you would like a copy of our sample DOT application and drug and alcohol inquiry information, just shoot me an email, and I'd be glad to share that with you as well. When you get the email, what it'll do, it'll click you over, it'll have a link, and it'll take you to a survey, and just give me feedback on how I did. It's pretty straightforward. We always want to monitor the quality of what we're doing, look for ways to improve it. So give me any feedback there. If there's any feedback you want to give me in the question section right now, I'd love to have it too. I'm always looking to get better. And beyond that, you'll get that link, you'll do the survey, and it'll take you to the link to download the slides, and it'll also provide the HRCI and SHRM information. If you don't get it by the end of the day today, look for it tomorrow morning, but also check your spam filter, because it does come, that email will come out of our constant contact account. So it may go to your spam folder, and so if there's a problem there, you check your spam. If you don't get it by tomorrow, though, tomorrow morning, shoot us an email, and we will make sure we follow up with you, because if it got hijacked by cyber gremlins, we'll fix that. And finally, Imperative is a background screening company. That's what we do. I would like to work with you. We really focus on small to medium-sized employers. We've got a lot of clients with one person in HR, or just one or two people, or maybe a recruiter and some sort of generalist or manager. That's who we love our large clients, and they help pay the bills as much as everybody else. But we love working with the small to medium-sized employers. I'm an HR guy and spend most of my time still consulting with our clients about all kinds of stuff, especially, like I said, in the areas of employee selection, recruiting, and employee relations issues. So our clients know they can rely on me to get information that they need when things change legislatively or whatever. And our blog is full. You can go look at our blog. It's full of that stuff. But also just the relationship we have with our clients. I want to be a consultant. I want to be of value to them and help them with their daily, HR execution. And hopefully we can make their jobs a little easier so that they have more time to be strategic and think big picture about how the company is going to move forward using the people resources they have. And so if that's the kind of relationship you need with your background screening company, that's who we're for. If you just want a piece of paper in a file, or you're just looking for the cheapest background check, we're not the right company for you. I wish you the best. Those clients tend to come to us after something's gone wrong, and they're having to clean up the mess of hiring the wrong person, or having the wrong person in the wrong seat. So whenever you're ready for us, please give me a call. But since there's no questions, I'm going to go ahead and close the webinar out. I hope all of you have a great rest of your week. And again, if there's ever an opportunity to help you, we'd love to talk to you about that. Thanks, and have a great day. Bye-bye.